All right, so this is Exhibit 10. So this is what Mike Howard said happened in the Karmelo Anthony trial. The state of Texas versus Karmelo Sincere Anthony. Affidavit of Mike Howard. Before me, the undersigned notary public on this day personally appeared Mike Howard, who being by me duly sworn, deposed, and state as follow. I, Mike Howard, and those of you guys who don't know who Mike Howard is, this is the lawyer that represented Karmelo Anthony during the trial. I, Mike Howard, am at least 18 years of age, of sound mind, and I am competent and qualified to make this affidavit. I have personal knowledge of the facts stated herein and that they are true and correct. I declare that. I was the trial counsel supported by second chair co-counsel Toby Shook, third chair counsel Tasha Gupta, and briefing appellate co-counsel Michael Mola, who represented Karmelo in the case number leading up to June 1st. Trial of this case, the defense and prosecution reached an agreement where the prosecution and defense jointly agreed to not raise any alleged character, reputation, and extraneous offenses / bad act evidence relating to Mr. Anthony, as well as Austin Metcalf and Hunter Metcalf during the trial herein after referred to as the agreement. The lead prosecutor in the case, Bill Werski, brought up the possibility of the agreement a number of times well before the agreement was discussed in detail and eventually reached. When mentioning a proposed agreement, Mr. Werski proposed that we try the case clean, which he defined as based only on what happened under the tent that day, under the Memorial High School tent at Kirkendall Stadium on April 2nd, 2025, and not go into character, reputation, or extraneous offense and or bad act evidence applicable to either Austin and Hunter or Karmelo. On May 5th, 2026, Mr. Shook and Mr. Werski discussed this proposed agreement by phone. During that phone call, Mr. Shook and Mr. Werski discussed the evidence of character, reputation, and extraneous offense / bad conduct as it applied to both the Metcalf twins and Karmelo Anthony. Now, it's important to note that Mr. Shook and Mr. Werski used to work together. So the two people who used to work together made this agreement on the phone. Interesting. The two people who used to work together because Toby Shook used to be a prosecutor, and so is Bill Werski, and they worked together. The two people that worked together made this deal on the phone. It stinks. It all stinks. On May 5th, 2026, Mr. Shook and Mr. Werski discussed this proposed agreement by phone. During that phone call, Mr. Shook and Mr. Werski discussed the evidence of character, reputation, and extraneous offense / bad conduct as it applied to both the Metcalf twins and Karmelo Anthony. Mr. Werski reiterated that he would be happy to try this without getting into character at all, just on what happened the day of the track meet. On May 8th, 2026, the defense and prosecution teams met in Collins County grand jury room. The prosecution team gave us a document entitled State's Notice of Intent to Use Extraneous Offenses hereinafter, State's Notice, and we gave to them a document entitled Anthony's Motion in Limine regarding the admissibility of pertinent character trait evidence under the ambiguous aggressor rule and evidence under the Texas Code, whatever that is. After tendering to each other our respective extraneous filing / briefings, we then discussed the proposed agreement, which Mr. Werski referred to as a gentleman's agreement. Mr. Werski outlined the proposed agreement as follows. Both sides try the case without character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony, and just try the case based on what happened under the tent and during another description during that meeting. What happened on the day of the incident? Seeking clarification, I asked and Mr. Werski confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins' character, reputation, and extraneous offenses / acts related to violence and bullying, inclusive of discipline and write-ups in the Metcalf twins school records within this framework, as well as racism. In exchange, the prosecution would not go into character, reputation, and extraneous offenses / acts, evidence relating to Karmelo Anthony, inclusive of the contents of Karmelo Anthony's cell phone and school disciplinary records. At this meeting, I sought clarification on how this agreement would work practically, specifically how to handle the possibility of opening the door to this evidence from either side. During this meeting, Mr. Worski repeatedly expressed his concern that the defense would kick open its own door by asking questions of witnesses that would delve into issues restricted by the agreement. I asked about specific statements made by witnesses interviewed by police and captured by video on the day of the incident, where those witnesses discussed the Metcalf twins being passionate, triggered, and not tolerating being disrespected, etc. Mr. Worski eventually agreed that questions narrowly tailored to ask specific statements the witnesses made to police about the incident under the tent on April 2nd, 2025, including statements just described about the mindset and actions of the parties involved in the incident, would not constitute kicking open your own door, and thus would not violate our proposed agreement. During this meeting, we discussed the terms of the agreement, being that testimony from eyewitnesses from under the memorial tent on April 2nd, 2025, and who were discussing the facts of what happened under the memorial tent on April 2nd, 2025, would be permissible, and that neither side would go into character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony. During this meeting, I also asked about the agreement regarding the possibility of the defense calling experts. The prosecutors only discussed how the agreement would apply to the defense experts during the sentencing phase. So I asked how the possibility of the defense calling experts to testify during the guilt/innocent phase would impact the proposed agreement. The prosecutor team replied that they had not considered us calling experts to testify during the guilt and innocence phase. They stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about a fight or flight response, they considered expert testimony like that to violate the agreement and thus open the door to character, reputation, and extraneous offense/act evidence. On May 11, 2026, Mr. Worski, Dewey Mitchell, Mr. Shook, and I discussed the proposed agreement again by phone. I informed the prosecution that we had an informal agreement on the proposed agreement, but that we needed to have a final conversation with Mr. Anthony and with his parents to confirm the final agreement. During this phone conversation, Mr. Worski confirmed that the agreement would extend to the sentencing phase of trial as well. Mr. Worski said that would mean that in accordance with the agreement, the prosecution would quickly rest its sentencing case in chief without going into any allegations listed in the state's notice. Mr. Worski said, however, that he would not allow a false impression to be presented to the jury by a defense witness, and that if such a thing occurred, he would respond by going into character, reputation, and extraneous evidence from the state's notice. After the defense asked about an Anthony family member testifying at sentencing, Mr. Worski agreed that the agreement would cover Mr. Anthony's mother testifying to the standard "I love my son, please show him mercy" type of testimony, but no further. What? Somebody said this gotta be fake. No, this is in his motion. This is what Mike Howard is testifying to. Who says, "I love my son, please show him mercy," and that's all you can say? If you guys don't see that this was a true railroad through and through, again, it shows that you are biased. I don't care what you think about the outcome of the case and how you feel like it should go. Nothing about this was fair. Nothing about this was just. In my opinion, all of this shows corruption all the way through it. Somebody said, was this before the trial? Yes. The trial started June 1st, 2026. This is talking about communications that they had May 11th. And then the next paragraph shows communication they had May 21st. The trial started June 1st. On May 21st, 2026, the defense and prosecution teams met with Judge Roach in his chambers. During that meeting, both sides explained the agreement to the judge, describing it again as both sides agreeing not to go into character, reputation, extraneous evidence as it applies to both sides during both guilt and innocence and sentencing phases, as long as no doors are open or false impressions given. We agreed that the best way to document such an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses. So it would cover both the Metcalf twins and Mr. Anthony. But if made public, would not trigger reporting in the media about bad evidence specific to certain witnesses, thus endangering a fair trial. On May 21st, 2026, I drafted the motion in limine as described above and sent it to Mr. Worski by email. It was hand delivered to the judge on opening day of trial. The defense understanding of the agreement. The defense understood the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or defense about the incident that occurred between Mr. Anthony and the Metcalf twins and their teammates under the memorial tent on April 2nd, 2025. As every description by Mr. Worski described the agreement to allow for testimony about what happened under the tent. And Mr. Anthony was obviously a witness to what happened under the tent. By the plain meaning of the language Mr. Worski repeatedly used, the defense always understood the agreement to cover Mr. Anthony's potential testimony just as it would any other eyewitness to the incident under the tent on April 2nd, 2025. Following the plain meaning of Mr. Worski's words, in describing the agreement, the defense understood the agreement to cover testimony by eyewitnesses such as memorial students underneath the tent at the time of the incident, Hunter Metcalf, students outside the memorial tent who looked over and witnessed the incident, and Karmelo Anthony. This understanding of the agreement was further confirmed by events that occurred after the motion in limine memorializing the agreement was drafted and tendered to the prosecution on May 29, 2026, after a meeting with Judge Roach, the prosecution, and the defense to discuss how trial security would be handled. The parties discussed the timing of the state's case in chief and when the defense case in chief would start. Mr. Worski informed the court and the defense that he estimated it would take 3 days for the state to present its case in chief, which would have ended sometime on Saturday, June 6, 2026. In response, I voiced concern to the judge in front of the prosecution's team that some of the witnesses the defense anticipated calling to testify were unavailable on Saturday, June 6. I explained that, like in any case, I would not know until the final moment whether we would call our client for sure, but that if the prosecution rested sometime Saturday, and the judge forced us to call witnesses immediately on Saturday, may not have enough witnesses available to fill up the full day of testimony Saturday. I explained that if this happened, it would force me to call my clients out of order. The defense plan was to call all our fact witnesses first to establish facts and then conclude by calling our client to testify as our last witness. On Friday, June 5th, 2026, the second day of testimony during the state's case in chief, I checked in with Mr. Worski about how he was proceeding on whether he would end up taking more or less time to present his case in chief than he had initially estimated. Mr. Worski informed me that he was moving more quickly than he had initially estimated, so the prosecution was on track to rest its case in chief midday Saturday. In this conversation with Mr. Worski, I again brought up the fact that several defense witnesses were unavailable on Saturday. And if the judge proceeded with this plan to force the defense to call witnesses immediately upon the prosecution resting in order to have a full day of testimony on Saturday, we might be forced to call our client out of order. This time, I did not preface this statement with the perfunctory, like in any case. I won't know if I'm going to call my client at the last minute because I was not on the record and I was speaking to call my client at the I was not on the record and was speaking frankly with opposing counsel. I was very plain about the defense intention to call Mr. Anthony to testify and how the judge's proposed schedule requirements were going to force us to call Mr. Anthony out of order. I don't independently recall what time on Friday, June 5th, this conversation with Mr. Worsty occurred, but it must have occurred just before noon because I then sent an email to Michael Mola describing the problem we were facing and asking Mr. Mola to draft a brief for us to argue to the judge that he couldn't force us to call our client out of order. Throughout the morning and early afternoon, let me change the page for y'all. Throughout the morning and early afternoon on Saturday, June 6th, Mr. Shook and I repeatedly checked in with Mr. Worski to get updated estimates of when he might rest his case in chief, each time referring to how the judge's plan was going to force us to call our client out of order. Besides the defense team repeatedly mentioning in front of Mr. Worski and the rest of the prosecution team that we intended to call our client to testify, even if it meant it would be out of order, Mr. Worski's own actions and arguments made it clear that he knew full and well that we intended to call Mr. Anthony to testify. Even before both sides tendered their notices of and arguments in favor of the admissibility of character reputation and extraneous evidence pertaining to the other side's witnesses, Mr. Worski made references to understanding that the defense sought to introduce character and reputation evidence about Austin and Hunter Metcalf that was uncommunicated/unknown to Mr. Anthony via the ambiguous aggressor rule from Torres v. State, the ambiguous aggressor rule and the admissibility of uncommunicated character and reputation evidence of the decedent in a murder case are all part of a self-defense argument. Torres discusses in depth how the ambiguous aggressor rule allows the defense to put on uncommunicated character and reputation evidence before or after the defendant testifies. Mr. Worski repeatedly brought up Torres in discussion with the defense team in the months leading up to the trial, stating that while he thought the judge would rule correctly and not allow the evidence, he conceded that character evidence could be allowed. This repeated discussion of Torres and how it may apply to the trial showed that Mr. Worski was well aware of at least the possibility of Mr. Anthony testifying in order to argue self-defense. This was the entire purpose of the agreement, in that it provided value to the prosecution, limiting the defense from presenting damaging character and reputation evidence against Austin and Hunter Metcalf. And the defense from the defense's perspective, the entire agreement centered around the defendant testifying without impeachment by character, reputation, and extraneous evidence in exchange for the defense not seeking to introduce character, reputation, and extraneous evidence against the Metcalf twins. Furthermore, any competent criminal trial lawyer knows that for a self-defense argument to have any chance of succeeding, the defendant must testify. For all these reasons, the defense always understood the agreement to include Mr. Anthony's testimony free of impeachment by character, reputation, and extraneous offense/bad act evidence. Just like every other witness either side could call to testify about what happened under the tent that day. The defense's reliance on the agreement. Throughout the trial, the defense revised the trial strategy in reliance upon the agreement. Absent the agreement, the defense intended to cross-examine each memorial student witness prosecution called about Austin and Hunter Metcalf's character and reputation for violence, for being bullies, and for racism. The defense also intended to cross-examine these witnesses about various statements they had made to the police on April 2nd, 2025 regarding Austin and Hunter Metcalf being easily triggered, having a loud mouth, being passionate, and not allowing themselves to be disrespected. What do y'all think so far to Mike Howard's affidavit, to what he went through behind the scenes as it pertains to this case? I dropped the link down below. If y'all want to come up and talk about what we are hearing so far, let me know. If not, I'll continue to read. But let me see what y'all say. Crystal Destiny says this is very telling. She said the call is coming from inside the house. I'm glad his parents kept it cool and kept their systems brief. Head to Mike Howard law page and child, I'm not gonna say do that because child, I'm gonna be holding some people accountable, so I can't, you know what I'm saying, but that's what y'all saying to do. I'm not gonna say do that because child. Anyways, click the link. Somebody said, how do I join? Click the link. I'm gonna post the link again. Click the link. You can come and enter. Let me know your thoughts so far, and then I'll continue reading. You keep saying this. I guess you want me to acknowledge that you keep saying, damn, you still live. I've seen you type that several times. Somebody said, this is bad, but good at the same time. Another person says, it's also scary. I don't even know how you deal with this one. Child, you laughing because you done typed this several times. Damn, you still live? Like, how you like, what you gonna keep writing that until I respond? Child, I keep starting to look shiny. Like, what the heck? I can't believe I've been on here talking to y'all for 7 hours. We cannot be shiny, girl. But anyways, all right. So somebody said, this is crazy. Thank you for your hard work. Thank you for realizing my hard work. But I'm trying to figure out, child, if you can't go to Bella Noche's, I'm gonna need y'all to support the stream. Like, we've been here for, most people would have been shut the stream down because, baby, y'all have not supported like that. But I'm keeping the stream going because, again, we are going to break down the live. But I'm trying, y'all could support by giving a little $1, $2, $20, $10 holla in my Cash App, NiqueAtNiteMedia, because baby, we are on a roll. All right, so let's continue. So it says, where we at? These witnesses, let's see. The defense also intended to cross-examine these witnesses about various statements they had made to the police on April 2nd regarding Austin Hunter being easily triggered, having a loud mouth, being passionate, not allowing themselves to be disrespected. Some specific examples include Austin's a really big guy and he's the aggressive guy on the team. Austin got the same way that he got during the altercation is the same way he got with some of us. And the mellow kid, something or whatever, and then Austin got triggered. Austin and Hunter, they're not going to let you disrespect them. And Austin, he's like a big guy, so nobody really wants to fight him. And Austin's really a passionate guy. And Jose told police about Austin's history of fighting and almost getting kicked off the football team for fighting. Another statement, I've known Austin for a while, and if Austin is about to get into a fight, you can tell. Another statement, Austin can be a bit aggressive at times, and he has a bolder mouth sometimes. If the prosecution did not call any of these witnesses, the defense was ready to call them during the defense case in chief and question them as hostile witnesses. Furthermore, the defense intended to call witnesses familiar with Austin and Hunter Metcalf's reputation for violence and bullying. The defense intended to call witnesses who themselves were thumbs of the Metcalf twins. Violence and bullying. The defense intended to question Memorial High School teachers about the Metcalf twins' disciplinary history contained in their school records, which corroborated their character for violence and bullying. And the defense intended to elicit testimony about the Metcalf twins' arrest for racist graffiti in good faith reliance upon the agreement. The defense did none of this. The defense even limited its questioning of witnesses about statements they had made about the Metcalf twins being triggered, having a loud mouth, being passionate, etc. That had been deemed to be allowed under the agreement in an abundance of caution to avoid opening the door. Furthermore, related expert would open the door to character, reputation, and extraneous evidence pertaining to Karmelo. The defense chose not to designate any experts and ultimately chose not to call as a witness a neuropsychologist to discuss how Mr. Anthony's epilepsy impacted his perception of threat and response, as that is relevant to self-defense, and a forensic psychologist to discuss both brain development of a 17-year-old as well as the fight or flight response as it applied to Mr. Anthony's actions. Y'all want to tell me that they didn't railroad this boy? Y'all want to claim that he got a fair trial? If you see all of this evidence and you think that he got a fair trial, you're full of shit. You're full of shit. You're full of shit. There's no way that you can see this information and not see how they totally screwed Karmelo. Michi, what's your thoughts?
Hey, good to speak to you, Nick.
Hey,
I've joined a bit late. I just curious about this door. So if we open this door, what happens?
then they would tell whatever bad information they had about Karmelo. They haven't mentioned what that is. It would open the door to bad information about Karmelo.
I say open the door. How bad can it be in
Right.
relation to what's going on? I say let's open all the doors. Let's put everything on the table. I
I
don't
agree.
understand why that was agreed to. It doesn't make any sense.
Right. Like if he didn't kill somebody, which if he just got into a fight with another student, let's put it all out there.
Exactly. It seems like everyone's got a bit of a history, so let's put it all out there. And in relation to all of that, then let's look at the case again.
I agree. That's why I want to know, like, what is this bad information that they have on Karmelo that they keep saying that they didn't want the door to be open, and they're not even saying it here. So it's like, what is it? There's rumors, but I don't want to go off of rumors. I want to go off of facts. So let's put it all out there. I say,
Absolutely.
if they did racist graffiti, if they had a reputation for bullying, if they were thugs that they sound like they were, put it all out there.
Absolutely.
There.
And at the end of the day, the aggressors were them. Camilla was sitting down. They approached him. I don't know why that's not taken into account. He didn't approach them and attack them. They approached him. So how can that be straight murder? It just doesn't make sense. I'm in the UK, and even in the UK, that makes no sense.
Right.
Anyway.
Somebody said pictures of him with guns. Well, there was pictures of both of them with guns. If they're going to use pictures of Karmelo with guns, there was pictures of Austin and his brother with guns too.
Okay, but is there evidence that he used the guns?
No, this
That
was
he's
in the
hurt
gun
someone with the
case.
guns? Okay, so a picture with a gun means nothing, but records of the brothers having a reputation of fighting regularly, being racist regularly, I think that holds more weight than a picture of Camilla with a gun that he hasn't caused any harm to anyone with.
Right. I agree
People
with
just
you.
want to throw things out of there. Oh, he had a picture with a gun. So what?
I agree. But I think that they were weighing it on, they know that that's a racist ass county, and they know, but still, put it all out there. Put it
Absolutely.
all out there.
I'm not sure why his defense chose to agree with those conditions, but I think considering that this is his life on the line, then I think they should have just opened all the doors, all the windows, and let's air everything out.
I agree. Bro, man, what's your thoughts?
Hey, thank you. I just wanted to know, like, I was trying to find out too, what is the benefit for Karmelo for them to make this agreement? Because it just screams to me inadequate counsel. He
Right.
wasn't able to get a good defense because now, if I'm right or not, I'm not sure. But when they're talking about character, right, that's both good and bad. So
Right.
the good character of Carmelo can't come out. The negative of them can't come out. Now, also, I had heard when the gun. I apologize, but
You talk, I'm gonna listen, but I'm gonna go tinkles. But go ahead. Don't say nothing that you ain't supposed to. Don't say nothing crazy. or none of that.
Okay.
All right.
Okay, I got you. Yes. Y'all subscribe. Hit the like button, bro. What's wrong with y'all? This is great content. Support the channel, bro. Subscribe, like, and share. But I was hearing that it was a prop that he was posing with, not necessarily an authentic, real tool. So I just think that, like what she's saying with the county, that they already had their mind made up the day that it happened and that they were not into doing the investigation. And then also when we see that the corruption with the prosecutor, the state guy Paxton, whatever office he had, he's also trying to get political favors from them. So just like it just screams of political corruption. And I think that we as a country deserve better. And I think that we all know that if the roles was reversed and Carmelo was the Caucasian kid, bro, that they would not have gave him 35 years for trying to defend himself against a mob, bro. And like my thing was also, if you got 21 witnesses and none of them can witness him possessing it or using it, like come on, bro. And then where are the adults? You mean that this tent canopy, whatever, is ran by the students? There's no adult supervision anywhere. I just think that that's a mistake by the school district and whoever was hosting the event and even the people that was in charge of that canopy. Because nobody knows what happened. It turned into a he said, she said. They're giving us grainy video. How are we supposed to be able to make our minds up with that? And then people who aren't really paying attention, they're just going to accept whatever and go on to the next thing. So I just think that we gotta move the best way we can, man, because we know that the deck is stacked against us. So I just want people to think before you do an action, bro. Make sure that you can live with the consequences of your action because it might feel good in the moment, but in the long run, was it worth it? And in this case, it's hard to determine if it was worth it in the long run. But I do believe this. If you were to ask the Anthonys or the Metcalfs if they wish their son would not have done what they done, that the Metcalf family would definitely wish that their son would not have done that.
I think they would still justify it personally. I still think
Okay,
they
go
would
ahead.
still say, I think they would still say, well, he had the right to, which he had no right to. He's a student, just like Carmelo was. It's like, how is it okay for a student to go to another student and demand that they move?
Absolutely. And I'm saying that I believe that his parents would prefer to have him here
Oh, absolutely.
than
But
to
I still
say,
think
oh, well,
the
he
dad
made
would
a
still
stand for a great
justify.
cause. Go ahead, Queen.
I think he would still justify that the arrogance of that family is unreal, in my opinion. Their sons can do no wrong, although the mum has slipped up in things that she has said.
The
You
mom
know,
would
she's shown
justify
her
it
son's
and the
character.
father.
They will always, even if they could change it, they will still feel that their sons were right, and it's disgusting.
But I'm saying, but so if they would have had a chance to be able to talk in his ear, they wouldn't have said, son, don't do that. We love you way more than anything that you're trying to stand up for right now.
If they knew it was going to cost his life, but if they didn't think it was
Right.
going to cost
Okay,
his
then. So
life,
then that's the person that, to me, made the biggest mistake. But go ahead. I
yeah,
apologize.
need to apologize. I hear what you're saying 100%, but I think knowing the outcome, they would have a word. But I still feel that they don't think there was anything wrong with their son's behavior. Do you get what? I still think
Oh,
that they would
absolutely.
justify his actions. They
They
wouldn't want it
would
to
both
end that way.
justify it because you see the mom justifying Hunter, like even down to her describing how Hunter was at the court the day of the verdict. She justified him going to Austin's girlfriend's house for 30 days. Oh, he didn't want to be at home, so he found comfort with Austin's girlfriend, but completely innocent. Like, girl, you make excuses for your kids. There's no
Yeah.
reason that he should have been laid up at Austin's girlfriend's house for 30 damn days.
Enablers.
What?
And
They're
then
enablers.
she was trying to shame the cheerleaders who were bullied by her fucking thugs, and
Yeah.
she tried to justify that the parents that released the evidence that her children bullied her daughter, that they were wrong. Oh, they were
Yeah.
just trying to get clout off of my son. They were trying to just get clout off of him. No, how about they were trying to tell their truth that your son is a damn thug and a bully,
Mhm.
and according to what Mike Howard says, a racist.
Hey, can I ask you a couple more questions, please? Is there anything in that paperwork talking about them not presenting the weapon, the tool in court? No
They did
DNA, no
present
fingerprints of Carmelo. Go ahead.
they did present the tool in court.
Okay. So did they have fingerprint evidence or DNA or?
I never heard them say that we got his DNA, but they presented it in court and they had testimony of kids who said it was his knife.
Okay, because I was hearing somebody say that it was a replica, not actually the official one, so I wasn't for sure. And
Well,
did they ever do his jacket? Because I think they said there was a couple drops on there. So did they ever come back and test his jacket to see if that was his, Austin, or anybody else's?
whose jacket?
Carmelo, the hoodie he was wearing on, he had a splat drop in on the front and on the back, as well as it having a little bit on his finger.
It's irrelevant.
And go ahead, I'm sorry.
Is
These are
that
irrelevant pieces of evidence, fam. He done that.
he admitted to it, so maybe that's why they didn't.
He
Then
admitted to what?
He
To
admitted
being
that he did.
he admitted to being a alleged suspect. That's
He
not a
admitted
crime,
to.
and that's not an admission of guilt or of a crime. Though, go ahead.
I don't think there's any doubt that what I think the issue is the circumstances surrounding it. It's not as simple as he just took somebody's life. Do you get what? And that's where my issue lies. We're not saying he's innocent and he didn't do that. He didn't produce what he produced and caused harm. He did, but it's surrounding the whole thing. Why did that happen? He didn't go there with that intent. That was brought to
Okay,
him.
King, but let me ask you this then. So you're saying that it was proven to you beyond a reasonable doubt that he did that?
He
I,
admitted
I
to
wasn't
it.
I wasn't in the court, but he admitted to it. But I didn't hear all the evidence in the court. We can
He
only go
admitted to
by what's
being
been
an
relayed.
alleged suspect.
He said he
No,
So
did
that's
it.
just like if the police are looking for me and they're saying, we think we found an alleged suspect, and I say, no, I'm not alleged suspect. I am the suspect that you're looking for. But that doesn't mean that I admitted that I broke any law or crime. I was just wondering because I've not heard.
ad,
Go ahead.
Freight train,
admin.
go ahead. You on here. Go ahead.
Okay, listen, man. He didn't admit to being an alleged suspect. When they said we got the alleged suspect, the man said I did that. And he was supposed to do that. They talking about they got pictures of him with guns. Black people need guns. Everybody need a gun. If you on here, you need a gun. Get a gun. Get a lot of them. Because they got guns. When you see them like white boys with guns, you don't see a thug. You don't see a criminal. But that's exactly what them twins were. Karmelo is a American. That means he has the right to have guns. I learned how to shoot guns at 9. This is not, ain't nothing criminal about that. What you do with them makes you what you supposed to be or what you ain't. All that extra that they talking about they don't want to open up they don't want to bring up this about Carmelo and don't want to bring up that about the twins. That is not to protect Carmelo on the defense side. That is to protect the twins on the defense and the prosecution side. See, people,
100.
this thing, right? Scientifically proven. Melanin makes you more compassionate. So, y'all getting this wrong, black people, I love y'all. But y'all looking at this all wrong. Y'all looking at this like the defense made a mistake. They didn't make no mistake. They did exactly what they plan to do. They did exactly what they plan to do. They are friends. They are on the same team. Do you see that march they just did in D.C. with all them folks with the masks on? Ain't no telling how many of them was police officers and judges and lawyers, defense attorneys. That's gonna have you thinking they your friend when they smile in your face and gonna hang you, gonna trade you like a basketball card. Them folks don't care about you, man. So looking at it like, oh man, they messed up. No, they wasn't never on your side. They don't have nothing to put up on that boy. That boy saves. If they won't pull up something, that boy saved somebody's life. Was in the newspaper. If they want to pull up something. He was a straight A student and the captain on the sports team. If they want to pull up something. It can't be nothing too bad. Whatever, you got to
That's
fight
why I
us on the
say
school.
open it
So
all
what?
up.
You can't have nothing too bad on that boy. The fact is, Toby Shook and Mike Howard and every other face in that courtroom, except for his parents and the black people who was crying for him, was on them folks' side, man. From the jump. This is Collin County we talking about. Listen, the Klan ain't even the leading, what you call it, white nationalists, whatever they want. They not even the leading bigots no more. But they still have national meetings right there in Collin County. They still have meetings right there. They don't bring their ass to Dallas. They not coming to Dallas. They know better. But they have meetings right there in Collin County. And mother folks, you see, they got their masks on, man. Them folks probably criminal. They probably got all charges and whatnot. If what's his name? What's the little boy that got the signs, got beat, slapped out of his head, and like, what's his name? Jake Lang.
Oh,
Jake
I was
Lang.
like, who?
If he decide once he get off this ankle monitor, or even if he own it, because they ain't gonna enforce it on him, they on his side too. But if he decide that he want to march around with a gun with some white supremacists, then all he gotta do is put a mask on. Who gonna bother? Ain't nobody gonna bother this boy. Who they gonna bother? Us. But we don't put no mask on. And we don't care what you got to say. Because we know the law. We read the law. Word for word. We know exactly what we doing. They don't want the law to stand for us. That's when they start talking about guns. When they see us with them. But we're Americans too. Matter of fact, we more American. We made this motherfucker. I'm sorry. I'm cutting. I'm
All
sorry.
right. Nah,
Yeah,
you good. Well, thank you so much. Stay backstage. Don't hang up. I'm gonna read some more of this this affidavit. Do not click off. I'm gonna bring you guys back up once I read a little bit more. And then I want you guys to chime in. So don't go anywhere. I'm going to just finish reading what it says. I don't know what part I left off on because y'all been getting into some things, but let's finish this out. All right. So it says, as a result of this revision, the defense strategy, the defense did not go into these subjects during voir dire or opening statement without such an agreement, or if the defense had suspected that the state would violate the agreement, the defense would have explored these subjects during voir dire and would have introduced these topics during its opening statement. In sentencing, in reliance upon the agreement, the defense did not designate an expert who was ready to testify regarding mitigation, i.e., a risk assessment and psychological profile of Mr. Anthony. Furthermore, in reliance upon the agreement, the defense severely limited its available character witnesses to just 3 questions of Mr. Anthony's mother, which had been previously agreed upon by the prosecution. Other than general character testimony and pleas for mercy, in reliance upon the agreement, the defense also did not go into substantial family violence Mr. Anthony had witnessed and been a victim of in his home. Notification of breach of agreement. On Saturday, June 6, 2026, after the prosecution rested its case in chief, the defense called witness Adam Linwood and then these others before ending the day in the late afternoon / early evening. On Monday, June 8th, 2026, the defense resumed its case in chief, calling Brendan Steffens and these other defendants. The defense next planned witness, blank, had been avoiding the defense's subpoena and kept changing the time he told us he would arrive at the courthouse. Accordingly, after Mr. Lacey's testimony, we took a break at 10:50 a.m. to see if blank had arrived. During the 10:50 a.m. break in the back hallway outside the judge's chambers, the judge asked us for an update about timing, how many more witnesses, etc. Explained that the next witness the defense had planned to call was a Centennial High School coach. Mr. Worski asked that the coach would testify to that did not pertain to Mr. Anthony's character. I explained that this coach had witnessed Mr. Anthony's seizures, so he would testify about Mr. Anthony's epilepsy based on his personal knowledge. Mr. Worski then argued that testimony about epilepsy was irrelevant at guilt/innocence, and to the extent it was relevant would open the door to character, reputation, and extraneous evidence against Mr. Anthony. In plain terms, it would breach the agreement, which I believe, and I'm ad-libbing for myself, that's bullshit. Because a medical diagnosis is not the same as character evidence. So, Mike, you were supposed to get this ruled on by a judge because a medical condition is not the same as character evidence. Like, what are you talking about? Like, what? So it says, Mr. Worski then argued that testimony about epilepsy was irrelevant at guilt/innocence, and to the extent it was relevant would open the door to character, reputation, and extraneous evidence against Mr. Anthony. In plain terms, it would breach the agreement. I stated that I disagreed, explaining how it was relevant to Mr. Anthony's state of mind pertaining to self-defense, and that it did not relate to character, reputation, or extraneous evidence. Good. But also, a medical condition is not the same thing. But Judge Roach agreed with Mr. Worski that he thought testimony about epilepsy was not relevant during guilt/innocence and would open the door. How? That's how this judge it was corrupt, like corrupt, in my opinion. Again, that's not a fact, but in my opinion, Judge Roach is corrupt. Like, what? How is his medical condition character testimony? It says Judge Roach agreed with Mr. Worski that he thought testimony about epilepsy was not relevant during guilt/innocence and would open the door to character, reputation, and extraneous evidence based on this. I informed the court that I would not call the coach and that I anticipated having one or two more witnesses before I would call Mr. Anthony. In response to the judge's question about likelihood of Mr. Anthony testifying, I told the judge that we would need to confer with Mr. Anthony about his Fifth Amendment decision regarding testifying, but I was 99% sure that he would, in fact, testify. After the break, back in court before the jury to give blank more time to arrive at court, we then called Frisco Police Department Detective Riley to testify. After Detective Riley finished testifying, then decided not to call blank as a witness as we broke for lunch early around 11:17 a.m. And this is when I seen the guy, the goon, the thug recording me, and then they parked next to my car. This that day, or was this a different day? I can't recall. But child, what day we on? What day they talking about? Anyways, maybe this wasn't that day. I don't know. All right, so let me see. It says, on the way back to chambers, Mr. Worski mentioned to Mr. Shook that from his perspective, I had already opened. Oh, this is June 8th. No, this ain't the day. June 5th was the day they was recording me getting my car and then parking next to me. This is June 8th they're talking about. All right, so it says, I had already opened the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony by saying that Mr. Anthony was a member of the chess club during my opening statement. I did not say anything about chess club at any time during my opening. I said that Mr. Anthony played chess during my background description of him and his hobbies. Mr. Worski also stated that from his perspective, the agreement did not cover a testifying defendant. Mr. Shook alerted me and Mr. Worski and Mr. Mitchell. Mr. Shook and I stood in the well of the courtroom, and Mr. Worski repeated these statements, adding that the prosecution never thought that the defense would call Mr. Anthony to testify. Back in the judge's chamber, Mr. Worski repeated his assertion that the agreement between the prosecution and the defense never contemplated a testifying defendant. He elaborated, stating that he never thought that we were calling Mr. Anthony as a witness. He also repeated his claim that I had already violated the agreement during my opening statement by saying that Mr. Anthony was a member of the chess club. It is important to note that was the first time Mr. Worski mentioned that he believed I had violated the agreement days earlier by mentioning that Mr. Anthony played chess during my opening statement. Although the prosecution and defense team had conferred many times throughout the prosecution case in chief about various issues, this was the first time Mr. Worski brought up this assertion. Judge Roach told both the prosecution and defense teams that my mentioning chess during the opening statement definitely did not open the door to character, reputation, and extraneous evidence applicable to Mr. Anthony. The parties argued about whether the agreement between the parties covered Mr. Anthony's testifying. The prosecution repeated their position, and extraneous evidence pertaining to Mr. Anthony were in play. Furthermore, Mr. Worski stated that time that the prosecution already had rested, character, reputation, and extraneous evidence pertaining to Austin and Hunter Metcalf was not relevant. When Mr. Shook and I mentioned the ambiguous aggressor rule from Torres, Mr. Worski argued that Torres did not apply because it was not ambiguous who the first aggressor was. That the first aggressor was clearly Austin Metcalf. At this point, the discussion devolved into a shouting match. Impact on the defense case. After the breakdown of the agreement, the defense and prosecution teams agreed to take 10 minutes to cool off before attempting to renegotiate parameters of how the agreement could extend to Mr. Anthony's testimony. Should the defense now choose to call him after the 10-minute cooling off period, Mr. Worski and I met in open court, outside the presence of the jury and without public in the room. Now, this I remember being outside wondering what's going on, what's happening. This was right after I broke down on stream, and there was all these thugs that came up there to intimidate me. And we just were waiting and waiting and waiting and waiting inside the court, wondering what was going on, while white supremacists were telling people to intimidate Black journalists. I remember this part because we were waiting. So it says that, where was I at? Okay, I read the wait. Okay, let me go back up to the top because where was I at? Child, I was like, it was putting me back there, like all this going on. We outside, they got white supremacists out here, all this stuff. So, anyways, it says, given Mr. Worski's expansive view of what he considered would open the door to character reputation. Wait, did I skip a part? Let me just start back at the top. Okay, after the breakdown of the agreement, the defense and prosecution teams agreed to take 10 minutes to cool off before attempting to renegotiate parameters for how the agreement could extend to Mr. Anthony's testimony. Prior to this, I guess the lawyers were arguing. It says, and they were having a shouting match or whatever. So it says that Mr. Worski and I met in open court outside the presence of the jury without public in the room to discuss possible parameters for the agreement covering Mr. Anthony's testimony. Given Mr. Worski's expansive view of what he considered would open the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony, especially his repeated claim, even after the judge stated otherwise, that even my mention of playing chess opened the door to character. I resolved that my only choice was to go over my planned outline of Mr. Anthony's direct examination line by line, Mr. Worski, to determine what would and would not, in Mr. Worski's view, open the door. I have never taken such a drastic step, previewing my strategy and even my questions with a prosecutor. But as a defense team, we agreed that we had no other option. We wanted to try to reach an agreement, understanding with Mr. Worski of how the renegotiated agreement would cover Mr. Anthony's testimony. As I went through my outline with Mr. Worski, standing reading the outline over my shoulder, Mr. Worski declared various subjects that, in his view, would open the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony. During this discussion, Worski repeated his claim that my earlier mention of chess opened the door. While I disagree with all of Mr. Worski's assertion of subjects that would open the door, I agreed to cut them from questioning in the hopes of salvaging the agreement to keep Mr. Anthony's strenuous offenses out if he testified. At the end of this discussion, with the understanding that Mr. Worski would extend me leeway to lead Mr. Anthony more than normal through certain aspects of the testimony, in an abundance of caution to avoid opening the door, Mr. Worski and I informed Judge Roach that we had to come to an agreement as to how the renegotiated agreement would cover Mr. Anthony's testimony. We then summarized the process we had just gone through and had our renegotiated agreement on the record. Prior to breaking to allow the defense to retire the defense room to discuss the issue with Mr. Anthony and his parents, Judge Roach informed us that he was aware of no mechanism at his disposal to enforce the agreement between the parties. Furthermore, Judge Roach informed us that he saw no way for Mr. Anthony to testify without the door being open. What dirty? That is, if this don't show you corruption, I don't know what does. How do you make an agreement with the lawyer? You say, okay, I'm gonna take these things out to make sure that I don't open the door, and then the judge backdoors the agreement that you just made with the prosecution to keep everything copacetic, and then say, what? I think it's still going to open the door if he testifies. Dirty, corrupt court, in my opinion. So where was I at? Okay. Furthermore, Judge Roach informed us that he saw no way for Mr. Anthony to testify without the door being open. For example, if he said that he brought the knife by accident or said that he was scared, etc., that this would almost certainly open the door to character, reputation, and extraneous evidence of some sort to clarify the issue. I proposed the hypothetical scenario that if Mr. Worski claimed that the agreement had been breached in some way, I and even the judge felt that Mr. Worski was operating in bad faith, that the judge was stating that he could not enforce the agreement, would have to make a ruling based on the Texas rules of evidence alone. Let me go to the next slide. And that in all likelihood, the door would have been open. Judge Roach confirmed that this was the case. We then broke to discuss the issue with our client. Judge Roach gave us approximately 10 minutes to explain the breakdown of the agreement and the proposed resolution with our client before the judge brought Mr. Anthony in for an on-the-record admonishment. During the trial, pre-admonishment meeting with Mr. Anthony and his parents, I did my best to explain everything that just happened. With the help of Mr. Shook and Miss Goop, we then returned to the courtroom for Judge Roach to admonish Anthony about his Fifth Amendment rights and also to explain that if he testifies, Judge Roach believed that he had no mechanism to enforce the agreement between the parties and would rule on the rules of evidence alone as to whether the door had been open. Judge Roach then gave us 10 minutes to discuss his Fifth Amendment rights with Mr. Anthony and help him ultimately decide whether he would testify. I asked for additional time to have such a complicated discussion with a 19-year-old in the most stressful situation of his life, but Judge Roach declined to extend our time beyond 10 minutes again. We did our best to explain everything, the pros and cons of testifying versus not testifying, the likelihood of winning on a self-defense if he testified versus if he did not, the likelihood of whether we would get instruction in the jury charge on the lesser included charge of manslaughter and criminally negligent homicide if he did and if he did not testify, and the likelihood of whether we could get instruction in the sentencing jury charge if we got there on sudden passion if he did and if he did not testify. During this discussion, beyond all of the above, the most complicating factor of all was whether Mr. Worski would claim that we had opened the door and then bring in Anthony's extraneous offenses / bad act characters or in reputation based on his actions and claims. Specifically, his repeated assertions, even after the judge had firmly disagreed that I had opened the door by even mentioning chess, as well as his general claim that the agreement had never been contemplated. Mr. Anthony testifying despite the plain meaning of the words Mr. Worski himself repeatedly used to describe the agreement. The defense team felt strongly that the risk of Mr. Worski claiming the door had been open was too high. This was amplified by the fact that Judge Roach made it clear that should Mr. Worski claim a breach of the agreement, he felt he was unable to enforce it and that in all likelihood, the door would have been open. At the end of 10 minutes, despite our request for additional time, Judge Roach called us back to the courtroom to announce Mr. Anthony's decision and proceed with the trial. Ultimately, Mr. Anthony chose not to testify. This 180-degree change in the defense strategy was the direct consequence of the breach of the agreement. The breach of the agreement affected all aspects of the defense case. By the time that the agreement was breached, it was too late to change our approach in voir dire and opening, too late to ask different questions of the prosecution witnesses, and too risky to recall those witnesses. Okay, by the time that agreement was breached, it was too late to change our approach in voir dire and opening, too late to ask different questions of the prosecution's witnesses, and too risky to recall those witnesses. To ask questions that would risk the prosecution deciding that we had opened the door. It greatly hampered our strategy during sentencing, causing us to decide not to call witnesses we otherwise would have called and severely limiting the questions asked of one of the witnesses, we did in fact call. The prosecution breach of the agreement directly and significantly undermined the defense's ability to present a complete defense. And this was signed by Mike Howard, and it was notarized, and it's going to be notarized until August of next year. All right. What's your thoughts, Freight Train?
Man, them folks misled that boy on purpose, man.
Do you want to be seen by the people? You're the only person in camera backstage. Do you want me to show you your thing?
I ain't got to be seen. I ain't gonna lie. I don't know how to turn the camera up.
Okay, go ahead. You don't have to show yourself. Go ahead.
I'm a little under the weather anyway. You probably heard it in my voice. But I don't like how it was done, how it played out, because them folks misled Karmelo on purpose, told him not to testify. Fam, if I'm saying I defended myself, I already said it's not alleged I did it. I got to tell you how and why I did it. I got to tell you from my mouth why I did it. Won't nothing help you more than that.
Right.
So the whole situation, all the judge saying if he testifies, gonna be brought up and all that. Man, the folks corroborated, make sure the boy didn't get on the stand. The lawyer told him, like he was on his side, that this is best for you not to get on the stand. Whole time it's best for the prosecution. And the prosecution they not trying to uphold the law. Them folks is literally trying to help them little old white boys over there who hate niggas. Hate us. I'm sorry. This ain't the whole situation, man. Wasn't nothing in his favor at all. And then the family is so trusting that they just went along with it because they can't really be blamed. They don't know it. They don't know what it is. They ain't from here. They from Louisiana. They can't really be blamed. They done paid this man their money. They done been pointed. Somebody that they trust again pointed them to this man. So they figured he was on their side. Whole time he against them too. I'm going to take your money and I'm going to hang your son and I'm going to watch your mama cry and I don't care. That's what the lawyers thought in his whole head. That ain't nothing right about them people. And they know ain't nothing right about them. And they still don't care.
All right. So, anybody else? Oh, go ahead. Sorry.
I'm sorry. So now that he got the dream team, as they call him, boy, got 6 lawyers, 6 fantastic lawyers. And they moving to get away from that judge and that court. The whole situation going to change. He going to come home free. It's not going to be time served. Time served is not an option because that's still on his record. That still hinders him in his life moving forward. He didn't commit a crime. He defended himself. You don't get to put your hands on me and tell me how to defend myself. Not in Texas. That don't work like that. If you put your hands on me and I'm fearing for my life, which he had every reason to be, it's raining. We on bleachers. I got epilepsy. I might have a seizure out here. Right. And you way bigger than me. If you put your hands on me, I got every right to defend myself. And he didn't keep on going when he poked Buddy. He poked Buddy one time and moved out the way. It ain't his fault he died. Hey, he defended himself. And self-defense is the only option.
Bro, man, do you have any thoughts?
Yes, I do. First off, I would like to say the prosecutor said that there was a breach in the defense attorney's opening, right? As far as him being a chess player.
Yes.
That is the most ridiculous thing I've ever heard. But now, here's the thing, though, right? As far as I'm aware, he didn't object at the time. And then the defense attorney is saying that the breach occurred so late that he wasn't able to make up for it. And I'm just like, how is Karmelo supposed to win with that? It happened in the opening. It was, in my opinion, ignored until it became a point of Karmelo potentially getting on the stand. Now, also, I wanted to ask you a couple things because it seemed like the prosecution was able to determine which witnesses the defense had, the jury, and then with the judge saying that he's not able to enforce the agreement. So, to me, that just means that there is no agreement.
And I think what Carmelo Anthony's lawyers were trying to convey is at that point when they found out that it was no agreement, it was too late. The jury already heard all of that. But at that time, it was up to Mike Howard to declare mistrial. He was supposed to, at this very moment, declare mistrial.
Absolutely. I agree with you. And the last thing I would like to know from you, right, is that if Karmelo gave an interview, would it hurt his opportunity and a chance for an appeal? Because for me, I don't think an appeal is going to happen anytime soon. I think they're going to try to delay it as long as possible because we see that they're not really trying to do anything to help Karmelo's case. Like for me, I like to play chess, right? And it's almost like they took Karmelo's queen off the board, both his rooks, and like pretty much he only had pawns out there. And So his team had to play checkers while the prosecution got to play chess. And I just think that it's sad. For me, let the evidence fall where it may. Just don't try to taint it and prejudice it because what it seems like happened. But I'd like to thank you once again. I know that you working hard and I appreciate you giving us this information in case because everybody is pulled up because we interested in the way you break down this content. So thank you very much. I appreciate you. God bless you. And we all praying that nothing is going to happen because of people trying to get the truth out in this case. Because that's the First Amendment in the Constitution is the freedom of the press. And when you have people trying to intimidate people so they can't get out the facts and nobody is coming to the defense of the journalists, I just think that that's a sad day in America. Thank you once again. I appreciate you. Free Karmelo.
Thank you so much,
A lot of
bro,
sad
man.
days.
I appreciate you coming up. Just to answer one of your questions, I don't think that he should do any interviews. Think that he should wait until his appeals go through or however the process is, whether they deny it, whatever, until those are exhausted. Don't say nothing because anything you say can and will be used against you. Michael, Andy, and OG Patrice, welcome. Michi, is there anything that you wanted to say?
Oh, yes, darling. I just wanted to touch on a few things, really. Like, in regards to his seizures and things like that, I think that's a really important point because people have different triggers for seizures. He was in a situation where he felt intimidated and fearful. So he may feel that being in that stressful situation could have caused a seizure. And to have a seizure in a position where you're very vulnerable, I think is an important factor in his way of thinking at the time. That's one thing I was thinking about. But also this whole thing about the character and his character being brought in or talking about the character and opening doors and all this nonsense. I feel like the prosecution they used his character at that time to push for his conviction. Because from what I hear, every witness that came up was led to imply that his character was aggressive and that he was the aggressor. That's talking about someone's character, but they only want to base it on the character at that instance. But what about the brother's character in that instance? Do you get what it's like? You can't pick and choose when you want to talk about character. Character is a big part of the whole situation. So for them to push back, obviously they had a fear of what bringing out everyone's character might do to their prosecution case. Do you get what? And also, I think giving him just the 10 minutes to decide on whether he would take the stand or not is shocking. Like his lawyer was saying, it's 10 minutes. That 10-minute decision cost him potentially 35 years of his life. Give this young boy 10 minutes to make a big decision whether he's going to speak up for himself or not, because that's basically what it is. And his thing is, if I speak up for myself, I have the fear of bringing out my character, which the prosecution will use against me.
And to digest what just happened, they said that it was a screaming match. The prosecution and defense were in a shouting match. They had to have a 10-minute cool off period. The stakes are high. They can't get one of the witnesses there. They're saying that they're going to be there this time. They're not there. Then they're knocking out what certain witnesses can say and testify to. And this person can't talk about the seizures and all of these things, and nothing is really going right in his favor at that moment. And it's just like everything is going against me right now.
It seems to me the prosecution
time to digest it.
Seems the prosecution was more scared about characters coming out than the defense, because for some reason that was a big focus for them and a big pushback for them. Well, if you do this, then we're going to do that. I think they were more scared.
Somebody's echoing.
It's not me.
That was me. I just muted my mic.
So that's basically what I wanted to say on that and what you just read.
Patrice or Michael, Andy, which one of y'all? Somebody said, Nick, did you get back up? Let me check. Hello?
I'll go because I wanted to piggyback off of what she was saying in regards to the epilepsy thing. I think the reason why the defense probably didn't move forward with if it was going to open up a Pandora's box, as if the defense was going to try to use it to say, okay, Karmelo was afraid that he would get an epilepsy attack, or if he get hit away, it could bring on epilepsy seizure. But I think that the prosecution would have came back with the fact that Carmelo plays a very high-powered contact sport, and that's football. I think that they would have came back with that, saying, oh, he worried about getting hit, but he plays football, which is a hard contact sport where if he gets hit in his head or paralyzed or something, it's the same thing. So I think that maybe that's the only thing I can think of is where the defense didn't try to push back on the epilepsy situation. But I think anything else other than that, I don't think it could have been as bad as anything that the Metcalf boys has done. Playing, because it is dangerous playing football or contact sports. So I think that that's where the prosecution would have pushed back on and say, well, you don't want to fight, but you can get hit playing this hard contact sport and blah. So I think maybe that's why. But anything else, I don't know. It's got to be something else that they're not saying there that's not being mentioned. But at this point in time, when you're fighting for your life, I feel, and I don't understand why the defense did not prep Karmelo while he was out of jail for that whole year while he was out. Why wasn't the defense attorney prepping him then to take the stand? You're fighting for your life. And in 95% of self-defense cases, you should take the stand. Good, bad, ugly, or indifferent. You should take the stand because they need to see that human side of you. They need to see the vulnerability in you. They need to see why you fear for your life. They need to see, yes, answer the question. I had that poker with you, like whatever the case may have been.
The impression, it sounds like he was under the impression that whatever bad act they had on him would be detrimental to his case. So it sounded like he was in a position where it was a lose-lose because they said that if he testified, it would open the door to these bad acts. So whatever that bad act is, they felt that it was so detrimental that they decided that they would just cease and not give him a full defense. So I'm sure that they advised him, oh, this is so bad thing that you did that you'll go to jail and you'll be guilty if this comes in. It sounds like that was the impression that they gave him.
Right, but the question is, it would have been on
the football and fighting situation. That don't go
as well as Karmelo.
Patrice, you cutting in and out.
Oh, okay. No, he was at now. Somebody has a back.
Patrice, go out and come back in or something. There's interference.
It's not me. He has his TV on. He has background on.
No, it is you. You're going in and out too. Like when you're talking, it's like going in and out.
Okay, no, but that's all I wanted to say. Those points there. But thank you. I appreciate you letting me up.
That part just came through clear. But you can stay on. Michael 90.
Okay.
I feel like it's just like it was fixed for him all around. There was nothing that he could do, if you ask me.
Elaborate. Go ahead.
They screwed him over from the start, even from the beginning with the Dominique guy, if you ask me. And I just think that no matter what he did, they were just inside the court system, they were gonna screw him over. His family didn't know anything about the court system. So what could you do about it? That's what I'm thinking.
Okay. You want to elaborate any further or?
That pretty much be it. I'm sleepy, so I might go to sleep. So, but I thank you for being up and like this because I probably would have went to sleep. But
well, I appreciate y'all. It's some of y'all who've been on here for the whole 8 hours with me. So y'all, OG Patrice been on here for the full stream.
Time out.
Shout out to y'all. What'd you say? You cut out.
But no, I said I done cooked and cleaned and short and everything and jumped on here to watch. I just
wait, Patrice, go out and come back in. Click the link again. Freight Train, you got her echoing. You got it playing in the back. You got to listen to us only through the thing. Patrice, click the link again so we can hear you.
My beat that was me again. I can't hear her. For some reason, I heard dude.
Oh, it's because she was going in and out. So hopefully she'll click the link again and maybe she'll come through clear now. Patrice?
I'm here. Can you hear me okay?
Go ahead.
No, I was just saying, I don't know, you guys. I'm fighting for my life. We've seen like court cases right on TV where, and I know it's not television, it's real life, but we've seen where some ugly things have came out about a person, right? That mistakes or whatever, or a past that they've had where it may flaw you. But I just don't think anything young man at 17 years old could have done that would be so bad. He wouldn't risk that, or his parents wouldn't want him to risk that. I would have wanted to show my humility. I would have wanted to show my fight in me, my fight for my life. And who is better to get up there and tell your story better than you? Good, bad, ugly, or indifference. Tell your story. Let people relate to you being human. Other than the fact that the prosecution would have came back with the football thing against the epilepsy thing. He's 17, like in his whole life. What could he have done so bad? What I'm saying, that it would have painted this picture of this mad guilt on him at 17 years old. So I think to see a vulnerable 17-year-old, well, 19 now, kid, and where his frame of mind was then at 17, and then to have an expert witness like a psychiatrist get up there and talk about the frame of mind of a 17-year-old whose brain isn't fully developed. There's so many other things that I felt like could have been a part of the defense that just wasn't. I just feel like there wasn't enough fight. There wasn't enough. When you're fighting for your life, all bets are off, like everything's off the table. This young man is fighting for his life. Whatever comes out, comes out. But it does not negate the fact that I defended myself. I was afraid for my life. And this is the position I was in then, at that time. Has nothing to do with the fact that had done something when I was 10 or 12 or 15. We're talking about now. What presidents does that set? The jury needed to see the vulnerability, the humility, the frightened, scaredness. They needed to hear his voice, his humbleness, all those things. And they needed to hear the great things about him. They didn't hear those things. No character witnesses were called. The woman whose child he saved. It's levels and sides to all us in life. We've all done things we regret. He's 17 years old at the time this happened. What in the world could he have done so bad? That's all I'm saying. I would have took a chance. I would have rolled the dice. I really would have. I would have rolled that dice. And I think maybe given a new trial, it may just happen. If he gets a new trial, new witnesses possibly, new evidence possibly, and possibly Karmelo can get up there and tell his story in his own words. I really do believe would make a difference from the jury.
Facts.
Right?
Yeah, to make
All
a
right.
I'm laying my plane there.
All right, thank you. All right,
You're
so
welcome.
we ended on page, and I'm already starting to lose my voice, y'all.